for one, the first thing I always ask myself, well, do they have the capacity, and the capacity to do what? Because the capacity to do some things is not the same as the capacity to do others. Do they have the capacity to hire me? Do they have the capacity to hire you or anyone else that's coming into contact with them? Do they have the capacity to manage their finances? Well, they may have the capacity to write a check, but they may not have the capacity to balance their checkbook and understand how much money they have, right? Two different things. Can they make decisions about themselves, their personal care, their health care, those kinds of things? Do they have the capacity to write a will, which is a very different consideration? Do I know how much money I have? Do I know who my children are still? Do I have the capacity to drive? A lot of people don't really have the capacity to drive, but the only arbiter of who has the capacity to drive is the Department of Motor Vehicles, and they will send people to a doctor to be assessed. Can they own guns? We're in Virginia. Lots of people own guns in this state. And if they've had them in their house for a long time and they have subsequently lost mental capacity, developed dementia, how safe are they having guns in their house? Right? I had this happen with a friend of mine, actually. It was her father, and she didn't realize her grandchildren were going to the house where there were a lot of guns, and she didn't realize until her father died that he had all these guns all over the place and they were loaded. And he, had completely forgot about them, put them away, and nobody knew they were there. Well, if a child had gotten a hold of them, that was a disaster waiting to happen. And this, this kind of thing, deciding what they have for breakfast. There are, I don't know if you have clients like this, but I certainly have clients like this who are in a pretty much a vegetative state. They can't decide what they're going to eat. They have really zero mental capacity to decide much of anything, even to have whole milk, skim milk, or anything else, and somebody else has to make all their decisions for them. The other thing I always look at is who my client is, and this is a very tricky area, and I think that this probably comes up for you guys as well. And the way I think of this from a legal standpoint is that it's a little bit like insurance defense for lawyers, and there's probably a similar analogy for you guys. I just haven't thought of what it might be. When you have automobile insurance and you have an accident, and part of your insurance says that the insurance company will defend you if you're sued, the insurance company provides and pays an attorney, but the client for that attorney is the person that was in the accident, and you, as the person who is covered by that insurance, have the right to make the decisions about the litigation, whether you want to settle, whether you don't want to settle, those kinds of things. So even though the insurance company is paying, the insurance company is not the attorney's client. So when I think about this with the kinds of families that I deal with, usually the old person is my client. I'm writing a will for them, or I'm drafting a power of attorney, or whatever it is. And the children are sometimes paying the bill, or have called me initially and engaged me. So it's a very tricky situation to remember, well, who is the client here, and to whom do I owe my attorney-client privilege, and to whom am I, when there's a disagreement between mom and child, who am I representing and advocating for? And that needs to be very clear to me all the time. One of the ways I remind myself of this, if I'm in a room, like a conference room or a meeting room, and there's an old person who I represent, I always sit next to them. And sort of make my presence known to them physically. I'll touch their hand or whatever to give them some assurance that I'm on their side, and that's my function. I like to meet my clients alone without the children present at all, if at all possible. If they must come with them, I do ask them to leave the room so that I can assess the client with. Most of the time, adult children are trying to help mom and dad answer questions for me so that I get good information. Sometimes they have bad intentions or are exerting what we call undue influence on mom and dad if they're present. And it's just much easier if they're not in the room. Mom and dad can answer me without worrying about what Susie or Tommy think. In their mind, little children, but the people who are right now taking care of them. Once I have them alone, I test them for capacity. And when I say test them for capacity, obviously I am not a doctor, and I don't have lots of time usually to assess their capacity. But if you go back to the example that I gave you at the beginning, 2 hours is a long time to sit with somebody and hear their story, only to figure out that they really don't have the capacity to be really engaging an attorney, most likely, much less being able to give me an accurate picture of what the situation is. So what I use is something called the mini mental status exam, which I'll talk about more in a minute. But I do actually assess them right then and there, so that if I think there's a deficiency, I can sort of stop things before we get too far, into the proceedings, before I have to say, look, you got to go to a doctor and get this person checked out. Before I talk more about assessing capacity, I want to talk about what capacity is. I'm using that word a lot. That's the legal definition. I don't know if you can see the whole thing, but like most legal definitions, to read that is a little bit like chewing glass. I don't think it's very helpful, but basically it just says you've got enough bennies in your head to know what you're doing and to enter into a contract. And there's a medical definition which is almost as bad in terms of its usefulness. I think the only thing in there that I find useful is this word consequence, that people need to understand the consequences of whatever it is that they're doing. In other words, if they sign a contract, they need to understand the consequence of the actions that they're taking. So we'll try to flesh out what it means to have capacity as we go along a little further. Legally, and I don't want to spend very much time on this, legally there are different types of capacity even within legal capacity. The capacity to make a will is different than the capacity to make a power of attorney, believe it or not. And they, so I have to know what it is that they want to do. Recently, there was a case that was decided here in Virginia that changed the level of testamentary capacity, which was already very low. It's now even lower. You know Jim Cox, I think, don't you, Elizabeth? Yes. You should ask him about this case. He was the lawyer that tried it all the way to the Supreme Court of Virginia. And basically what it says is that people have capacity despite, or they can have capacity despite a very grave illness or diagnosis or brain injury such as Alzheimer's. In other words, a diagnosis of Alzheimer's does not de facto mean that they do not have mental capacity. So, we have to be very careful when somebody says, oh, well, my mother has Alzheimer's, she can't write a new will. And it's like, well, that's not necessarily so. So that's kind of thrown a wrench into the works for those of us that do this kind of work all the time. The capacity to make a trust, which is very much like a will, actually is a different form of capacity. It's the same as a power of attorney, which is the capacity to contract. And this is the one I think that's going to be important to you because you guys do work under contract. So in order to sign someone to a contract, they must have contractual capacity. And this one is a pretty good definition. Pretty short and pretty easy to understand. I'm not going to read it for you. You guys can read it for yourself. But I do give you an example which I think bears contemplating a little bit, because a contract, most people think of a contract as something that's written down and you sign and it's in place. But a contract is really any kind of agreement where two sides agree to do something. So if a doctor is asking a patient to take a very serious drug, they agree to that, and if it has potentially serious side effects, they have to be informed of what those side effects are. That's an agreement, that's a contract, and they are consenting to take a dangerous drug. So they have to have the capacity to contract, to agree, and they have to have what's known as informed consent. So in other words, the doctor has to fully explain to them, and they have to understand the consequences. So if that person really doesn't have mental capacity, they can't consent to a drug like that. Someone that does have the power to consent for them must consent. So I think that's a really important concept for folks in your position. You're going to run into that kind of stuff all the time. One of the interesting things that's a little bit tricky that I tend to use a lot is this idea that everyone over the age of 18 in Virginia has capacity, unless somebody says otherwise. And that somebody has to usually be 2 doctors or a judge. So just because the son or daughter says, oh, well, mom or dad they're not with it, they don't have the capacity to do that, that's not good enough. And that could be easily challenged. And you say, well, look, if you want to say mom or dad is incapacitated, you need to get their doctor to certify in writing that they are incapacitated. And it usually fouls up what they're trying to do with mom or dad if they haven't done that yet. Because mom and dad have the right to make their own decisions until somebody says they can't. And this concept is the one that is so hard for people to grasp. The law, there is no requirement that says a decision has to be good. You can make foolish decisions as long as you have the capacity to make a decision at all. And I call this the decision-making meter. And what you're looking for, there's a picture of it, what you're looking for is whether that needle is moving at all in either direction. So, on the one end, you've got foolish, silly, bad judgment decisions, but they're decisions. And at the other end, you have really good, rational decisions. But if that needle is stuck at the top and they're not able to process information and data in a rational way, not necessarily a good way, but they're able to take in the information, move it around, apply it to their own situation, and come up with a decision on one side of that meter or the other, they have decision-making capacity. It's hard when somebody's doing really silly things to say that they have mental capacity, but if you keep this picture in mind, it's a little bit easier. This is one of those things that I run into all the time. I run into it with families. I run into it in my own practice with people. And that is, you can't read the top of that, but it says treating someone as though they lack capacity. And why would we do that? The big reason that I run into a lot with families is that because somebody else has the power of attorney. Well, because somebody else has a power of attorney does not mean that they can substitute their judgment for mom or dad's or grandpa's or grandma's or whoever it is. That is not what a power of attorney does. A power of attorney is meant to give the person who holds that, and they're called an agent. They're not called a POA. They're called an agent. It allows them to carry out the principle, the person that gave them the power. It gives them the ability to carry out the principal's wishes. And the only time that changes is when the person has lost capacity, and the agent must then carry out what he thinks his principal would want, or what is in the best interest of that person. But it is never the substituted judgment of the agent. The other reason that we do this, let someone else make the decisions, is because it's easier. We often have difficult clients who, for whatever reasons, whether it's mental illness or just cranky, they're just really difficult to deal with and get them to make up their minds about things. And if there's somebody else around that we can turn to and have them make a decision, we do it. Not really kosher under the law. This is also a big factor with the really old folks usually. If their hearing is impaired, if you have a cultural difference with them and there's difficulty communicating with them, it's just much easier to turn to a son or daughter who is used to dealing with mom and dad and let them make the decisions. And it means we have to work a little harder to deal with a person that's impaired in whatever way they are. As long as their capacity is not impaired, we have to get through those other issues to be able to get them the information. So this is the definition that I really like. This is the one that I think comes from the American Psychiatric Association. And these are the elements that make up mental capacity, that they have some memory. They don't have to have a full suite of memory. They don't have to remember what they had for breakfast. Because most of the old people I deal with, and even I, don't often remember what I ate for breakfast. But I remember who my children are, or what kind of car I drive, or some of those things. Logic is a kind of subjective opinion. What somebody else's logic may not match what I think is logical. But the fact that they're able to take in concepts and manipulate them is the measure of logic. Ability to calculate, and literally I mean calculate numbers, and this is also very difficult to describe, this turning their attention from one thing to another, but you've probably seen this with people that you work with, where you go into their home or whatever and they're intently watching television, and it's very hard to get them to move to another task. They're intent on their program and they're like, won't turn away, don't hear you, tune you out or whatever. They may have dysfunction that's making it difficult. It's not just that they're engrossed in their program or their card game or whatever. The business about assessing mental capacity, this is always a very difficult thing. I use something called the mini mental status exam, which is used by just about everybody to assess mental capacity. It is not a definitive measuring tool. And what I copied for you guys, I'm going to give you, if you'll just take one and pass it around, that is the portable mini mental status exam questionnaire. And I don't think, there's 2 pages to it. I don't think I stapled them. And that one's one that I use. I don't even need to have the printed thing with me. I know those questions now well enough to be able to use that with my clients or prospective clients. And it's 10 questions. You can score it in 10 minutes or less. Conduct it and score it in just a very short period of time. And I just want to call your attention to 2 questions that are on there. These seem like really simple questions. And they are simple questions. I think it's question 7 and 8. One of them asks, who's the President of the United States? And the next one asks, who was the President of the United States before that? And I'll give you an example of how this test served me well. I had a guy who I was asking these questions of, and I asked him who was the President of the United States, and he thought about that for a second, and he said, it's some black guy. And I said, good enough. I mean, he obviously knows that it's a black guy, and we haven't had many of those. And I said, well, so who was the president before the black guy? Some other black guy. We may have a little problem over here. So they're simple questions, but they expose more than you would expect them to expose. And what they expose for me is when there is a deficiency. It doesn't tell me how much or how little, how bad this person's memory is impaired, but it tells me that I need to get a professional opinion. And that's when I send them to their doctor. What I do typically is I write a letter to their doctor saying, my name is so-and-so, I'm working with your patient so-and-so, and I need you to examine them to assess their mental capacity to do this. And I'm very specific about what it is that they want to hire me to do, whether it's to write a will or a power of attorney or whatever. And then I tell the doctor what that means they have to be able to do. And then the doctor will write, I'll give them sort of a format of what they need to tell me. And an envelope, so they'll return it to me, because they never do anything unless you do that. Then I have some documented means of, documented means of supporting what I've done for them. So if anybody ever comes to me later and says, well, that person really didn't have the capacity to do that, and I said, well, their doctor said they did. We had them specifically examined and certified to do just that. So it's kind of a CYA maneuver on my part, but I think it's a protection for my client too. I really want to know that they understand what they're doing. The other tools that are out there for use, and I think I sent these to Elizabeth already once, the APA, American Psychiatric Association, ABA, American Bar Association guide for lawyers, judges, and there are other professionals who do this kind of stuff. And they got together and they came up with a very comprehensive questionnaire that's intended specifically for lawyers, and I think it could be adapted for GCMs if you look at that. And I have that. I was going to copy it for you, but I'll make sure I get them to you if you don't have them. There's a guy by the name of Dr. Bennett Blum, who is a forensic psychiatrist, and he is the expert, the go-to guy in these matters. He's done a lot of work, mostly in criminal cases, including international criminal cases, the Yugoslavia war crimes, and some other very high-profile cases. But he does do civil litigation work as well, including will contests and things like that. And he has a very extensive body of work on capacity if you want to look at it. He's the guy to go look at. And I talked about medical evaluations already. I don't need to beat that horse to death. So when I talk about the people who, when somebody can't, when it's determined that they don't have capacity, who can make decisions for them, and I'm sure you've run into this already. You probably have clients where one or more people have a power of attorney, and those people are the ones that make decisions for them. Powers of attorney come in a couple different flavors, and a general power of attorney is typically about stuff. It's about property, banks, checkbooks, money, and real estate, all those sorts of things. It's about finances and personal business. A healthcare power of attorney or a medical power of attorney is about the person and their health care, where they live, what hospital they go into, what nursing home if they have one. Those kinds of decisions are made under a healthcare power of attorney. You will, on rare occasions, see one power of attorney that embodies the language of both of those, but frequently not. When I write them separately, two different documents. And the reason I do that is because families have different people who are good at different things. Often they have one child that's very good and detailed about handling money, and another person who has health background or is immediately available to make those kinds of decisions, and they're best suited to do that. My directive to most people on issues of power of attorney is read it. Don't let somebody just tell you, well, I have power of attorney, I can make these decisions. People try to make healthcare decisions about people over whom they only have a general power of attorney. They are not empowered to admit them to a nursing home or do any of these other things. They need a healthcare power of attorney to do that. Same goes for writing you a check. If somebody writes you a check and says, oh, well, I'm a power of attorney, and they flash a power of attorney under your nose, and you simply accept that that allows them to write a check, guess what? If it's a healthcare power of attorney, they have no more authority to write that check than the man in the moon. So read it. Actually look at it. A guardian is a court-appointed person who is responsible for the person, just like the healthcare power of attorney. They're responsible for their well-being and their care and that sort of thing. The conservator is responsible for money and things. So you can see a parallel line here. They're court-appointed, but they parallel the healthcare power of attorney and parallel the general power of attorney. The guardian and conservator are the court-appointed versions of those, but they are much more, I can't think of the right word, but I want to say powerful, or sweeping, I guess is the right term, and they have a great deal more responsibility as a guardian and a conservator. You also have a responsibility to report to the state. You have to, as guardian, you have to report to social services. As conservator, you have to report financially and extensively. I'll never do it again. To the Commissioner of Accounts through the courts. This last one is the one that I think most people don't know about and should know about. It's an individual who has no advanced healthcare directive or healthcare power of attorney. It's an individual who would be able to be spoken for under the Healthcare Decisions Act. I'll talk about that a little bit more in a minute. The other one that many people don't know about is a representative payee. Oh, it's a representative payee. The government, the federal government specifically, does not understand what a general power of attorney is for purposes of things like Social Security or VA benefits or railroad retirement. They understand what a representative payee is. And a representative payee is someone that takes care of somebody's money for purposes of the federal government. So if someone has no capacity and you need to manage their Social Security money for them, you need to become their representative payee for Social Security purposes. And you may not use that money for anything other than what is designated by the Social Security Administration. It's deposited in your checking account rather than theirs, and you have to account for it at the end of the year, how it was spent on their care. So this Virginia Healthcare Decisions Act, this is very important. Anybody remember this person? Yeah. That is Terry Schiavo. And I don't like to look at her for too long, but it's good to remember her. And I don't know if you remember the story or not, but she had a massive heart attack at 36 and never recovered. And she was unresuscitated for long enough that she did not have oxygen to the brain, and she was in a coma, a full-on coma for I think 3 months. And they tried to do all sorts of physical therapy and alternative therapies to try to coax her out of the coma, and they changed her diagnosis to persistent vegetative state. And she remained in a persistent vegetative state from 1990 to 2005, 15 years. And if you remember, it was her husband and her parents who disagreed about a feeding tube that was the only thing that was really keeping her alive, that if they disconnected the feeding tube, she would die. And the problem was that Terry had never expressed in writing what her wishes would be if she were to find herself in this situation that she was in. And her parents said, well, they said that she would want to live, and he said, no, she told me she wanted to be unplugged from any kind of life support. And they battled in the courts from 1999 to 2005, all the way up to Congress and George Bush. And you probably remember that part of the story. But as a result of that, most states in the United States drew up a Healthcare Decisions Act. And the Healthcare Decision Act in Virginia is quite lengthy, and it talks about what should be in an advanced healthcare directive. There's a form included in it and so if you get a power of attorney, a healthcare power of attorney that's from Martha Jefferson or UVA or whatever, it's based on the one that's in the Healthcare Decisions Act. And the overlooked part of this act is the part that I've put up there for you, is what happens when somebody does not have an advanced healthcare directive and finds themselves like Terry Schiavo in a situation like that. Who can make decisions in place of the person that might have been appointed if no one's been appointed? So they set up a list of people that can do it, and it's a hierarchy. In other words, and you can't see that, it's right off the screen. The first person up there is the guardian. If there is an appointed guardian for that person, they have first dibs at making decisions for someone that's incapacitated completely and on life support. The next person in line is the spouse, and this is pretty logical. You would expect this to be the case. And then there are adult children. And the obvious question is, well, if there's more than one child, how do you make the decision when there's more than one child? Because you can bet your bottom dollar they're going to disagree, and they do. It's a majority of people within a class. So if there are 5 children and 3 of them want to do this and 2 of them want to do that, you're going to do what the 3 of them want. What if there's only 2 and they disagree? I have that problem exactly right now. I don't know the answer to that question. I think I'm going to find out. I'll let you know when I do. And then it just goes on down the line. If there's a parent, adult siblings of the patient, and this is kind of, so if there's nobody else, any other relative of the person, and if there aren't any relatives, any other person. So that that says, oh well, I know them, I go to their church, and but there are some limitations on what they can do. So that's important to know, that you have that fallback position. Well, a lot of people ask, well, why should I bother to write an advance directive then, right? Well, what if you don't want your spouse to make that decision? What if it's somebody else? Or what if what if you know your children are going to war about this and not actually carry out what you want them to do? You might want to name somebody else to do this. That's the purpose of writing your own advance directive and healthcare power of attorney. All right, we beat that horse to death. And I'm sorry you can't see the top of these. This is a tough situation when you start getting into the place where capacity fails. And I'm going to bet that what's going to happen in your guys' instances, and Elizabeth, you can speak to this when we get to the place where we can talk more interactively, that this is a degenerative process often, that you may take on a client who has capacity when they hire you to do whatever you're doing, but over time, and sometimes a very short period of time, they lose it. So then what do you do? And one of the things that I'm very aware of is that there are instances where you know that someone has declined and they no longer have capacity, and it's permanent. And that's very sad, but as a lawyer, I have a responsibility to make sure before that the pieces are in place for them to be able to manage their affairs, that somebody is put in place as POA and that sort of thing, so that they can avoid guardianship and conservatorship proceedings and things like that. But there are other instances, and I really wanted to call these to your attention because a lot of people don't know this unless they have some medical training. There are conditions, and quite a few of them, that mimic Alzheimer's, dementia, psychosis, and those sorts of things. A very common one is urinary tract infections, which are treatable. A course of antibiotics, and they're fine. But there are some others. Drug interactions are a big culprit. When you go into some of these people and they're on 30 drugs, even the doctors don't know what kind of interactions they're getting, and the only way to get at that is to slowly take people off as many as you can get them off of, and start adding things in only as they're needed. But the point is, they may seem like they don't have capacity, but they will regain their capacity. So don't have them declared incompetent or incapacitated until you've checked all the medical possibilities first, because it's very hard to undo a declaration of incapacity. Time of day is also a factor, and people find this a little interesting. You may have run into sundowners. They literally go to the light at the end of the day. People who have Alzheimer's, if they're a sundowner kind of person, they will follow the sun during the day. If they're in a big room like this one, they would follow the light during the day, moving more towards the light as it goes. But as the light goes at the end of the day, they begin to act out and have very negative behaviors and are very difficult to deal with. But in the morning, they may be very cooperative and be able to think very clearly. And what a lot of people don't understand is that in that state, when they have capacity in the morning, I can get them to sign a power of attorney, as long as I'm assured that they understand the consequences of what they're doing. At 4 o'clock that afternoon, they may be a raving lunatic. But I can actually, as long as they have, capacity can be a very temporary, fleeting thing. But if they have it, we can take advantage of it while they have it. It's very risky, and I would want lots of witnesses to do something like that. But I can, if I have to. A couple of terms I think you should know about. Representative payee, I talked about. Another term that you'll hear in nursing homes, that's what NF stands for. I'm sorry, I try to avoid mysterious abbreviations, but NF stands for nursing facility. They use a term called responsible party all the time, RP, they'll call it. And an RP is a contract term that somebody signed when they checked the person in. It is not a legal term. It doesn't empower them to do anything or make any particular decisions. It's the nursing home's effort to cover their butts for purposes of liability, saying the RP made this decision. The responsibility falls on them. They're the responsible party. We called them. They made this decision. We didn't. But it doesn't empower that person to actually make those decisions. It's a really kind of bogus term. I always tell people when they sign into a nursing home, if they're taking a family into a nursing home or an assisted living, don't sign those contracts. You don't have to. They're not going to tell you to go away. They're going to admit you're a person, and you don't have to sign that contract. Certainly do not sign it while that person is being admitted. It's usually a very emotional, stressful time to take someone into one of those places. Everybody's confused. Everybody's overwrought. Take the contract home and have somebody look at it before you sign it. And you don't have to sign it. The person that's going to be cared for is responsible for how they're going to get paid. POA, we talked about it. The question you want to ask is, what flavor POA are you looking at? Is it healthcare, or is it general, or is it both? Does it have language that it is also possible to write very narrow powers of attorney, very specialized powers of attorney. I did this on one occasion where I wasn't sure that the person that the principal was empowering was entirely honest. She had lots of credit and judgment problems on her background, and I was very worried about her bilking him of his money. So I wrote the power of attorney so that she could not do a transaction of more than $100 without my authorization. So hopefully people read that power of attorney. I don't know that they did. People often don't, but I can write them that way. Guardian, again, you need to read the guardianship order. And is it broad or is it limited? By default, if it doesn't say otherwise, when you get guardianship, that person can no longer vote. They can't own guns. There's a lot of things they can't do. They lose all those rights when you become their guardian. You can carve them out. You can ask the judge to say, let this person still vote, or whatever, or any other thing that you want to allow them to be able to decide on their own. But it is not by default that the guardian is also the conservative. They often are the same person, but the order has to say that the person is a conservator and has the rights over their money. A guardian on its own does not have any rights to manage their money, which is crazy because it's hard to get anything done unless you have that power. But a couple of the things that are of interest more to my lawyer friends than to you guys, but I'll quickly go over them. We talked about the Medical Decisions Act already. I won't go over that again. This is of big interest, third-party payment guarantee prohibitions. And I think I'll illustrate this with a case. I'll put the statutes up there so you can read them if you're interested. There are federal laws and Virginia laws against the practice I'm going to describe to you. When I had a client who was the mother of a woman with MS, very severe MS, and she had been institutionalized for some time in a nursing home down in Louisa County. And the nursing home, when they admitted her, had the mother sign the admission contract as RP, responsible party. She also had a power of attorney. So she admitted her daughter to this nursing home, and something happened where the payments to the nursing home got fouled up, and they owed a lot of money, and I forget how much it was. I want to say it was like $35,000 or something like that over a period of time. And the nursing home went to the general district court, so it had to be less than $35,000. It was a circuit court. So went to the court, swore out a warrant in debt for that amount of money, and served it on the mother. The daughter is in the nursing home, served it on the mother, a third party, right? Yes, she's power of attorney. Yes, she signed as RP. However, she is not personally liable for her daughter's care. She is a fiduciary for her daughter, and they could have sued her as her daughter's fiduciary, and they could have claimed her daughter's money, her Social Security benefits or anything else that they had, but they could not go after the third party personally for that money. And what astounded me was the court had no idea about this. Nursing homes have been doing this for a long time. They just go into court, they get a judgment against the third party, then they have a judgment, so they can enforce the judgment. They can take people's houses, they can take their cars, they can take their bank accounts, garnish their wages, and they do, because most people do not know this, including the judge did not know this. There were 3 people in court the day that I went with her on the hearing on this suit who had been sued by the same nursing home. They had no idea. They had no lawyer to tell them about it, and the judge had no idea. Had it not been for the fact that this lady had hired me and I happened to know this, he said, "Counselor, do you want to defend these other 2 people?" And I said, "Sure, why not? We're all here together. Let's get them all off the hook." Because they're panicked, you know. And what typically happens is when the nursing home sues these people and the third party knows there's $30,000 coming up, they're so scared and frightened and overwhelmed that they don't even bother to go to court. Then what happens? Default judgment. And now they really do owe the $35,000 because there's a judgment, right? So, you know, if you hear of a situation like this where someone's getting dunned for somebody else's nursing home or assisted living bill, it's illegal. They can't do it. And I'll be happy to defend them if they need to go into court. So I've put in here a couple of websites that I think you might find handy. The first one is that APA site, and I printed the questionnaire for you, and it's pretty short, but there's a whole big 80-page PDF that talks about all of these issues that I think you might find useful if you have a continuing discussion about what GCMs are going to do on mental capacity issues. Dr. Bloom's website, which you might want to just sort of take a spin around and take a look at what he's got posted up there. Healthcare powers of attorney, one of the biggest problems with them is that nobody knows somebody has one. I recommend to everybody that they upload it to this site, which will spit out a little PIN number, which you can put with your person's Medicare card. Just stick it in there, and if they have to go in the hospital or to the doctor or whatever, what's the first thing they ask for? Their insurance card, right? The Medicare card. The PIN number will tell the doctor that they have a healthcare advanced medical directive uploaded in the central registry in Virginia, and it can be downloaded from anywhere in the country. So that's a good thing to know. It's new. They just started doing it in December. That's it. That's all I got. The question was whether a power of attorney needs to be a durable power of attorney in order to survive incapacity, and the answer to that question is yes. And what makes it durable is the language in the power of attorney itself that says exactly that. This power of attorney survives incapacity, and there's some sort of phraseology that's very specific about that. So yes, and when I write a power of attorney, I also put in there the specific language as to what's required to make a determination of incapacity. 2 doctors in writing, because otherwise, you know, it's not necessarily clear what does incapacity mean. So I just put it right in there. The other thing I put in a power of attorney when I write one, usually people, the ones that I see that other attorneys write, go on and on and on and on and on and on and on about what the agent can do. Bank accounts, real estate, bring lawsuits, blah, blah, blah. What I decided was as important, if not more important, was to put in there what the agent's duties are. That they have a duty to account, that they have a duty to keep the funds separate, that they have a duty to do, I don't know, there's 8 or 9 things in there. Because I don't think agents know that this is not a gift, right? This is a responsibility, and I wish we could change the name of it to power of responsibility, or responsibility of attorney as opposed to power of attorney. Even the people that grant powers of attorney do not understand that they are not giving someone the keys to the cupboard, that they have a responsibility to do what the principal wants them to do, and that they can be revoked at any time as long as they have capacity. Once they lose their capacity, they also lose the right to revoke their power of attorney.
Can I follow up on that? So there are powers of attorney out there that are not durable powers of attorney. So that language, you need to be really clear to check
Yes.
that language.
Yes. And it usually will say also right at the I do, it's not required to do this, but I usually write in the title, durable general power of attorney. But the language that needs to be in there, it needs to say somewhere in the text that this power of attorney is intended to be a durable power of attorney surviving beyond capacity. If the power of it, or if the agent disagrees with the principal and says, I'm not going to carry that out as your agent, that's too foolish and I'm not going to do it, they've resigned their power of attorney. So they may try to use that as leverage, but then the person who is your principal simply appoints a different power of attorney. If they can't agree, they should revoke that power of attorney and pick someone else to do that. And by the way, I should say the agent does not have to be a family member. It does not have to be, it only has to be someone they trust. It could be a minister, it could be an accountant or some other person who handles their affairs for other reasons. It can be anybody so long as they trust them. I do not, as a matter of practice, generally write powers of attorney that appoint me because it's an inherent conflict of interest to do that. But I think to answer your question, yes, that's exactly right, that they may have memory loss, but that does not entitle someone to substitute their judgment for them. Yeah, and my feeling is, and to jump on that a little bit heavily in terms of what their rights are, they have a hard time asserting their rights because of the situation that they're in. And they rely on people like me and you as the people that have been hired to help take care of them, to help them assert those rights, which sometimes puts you in a very difficult position if the person that's paying your bill is the very person who is adverse to the decisions that mom or dad wants to make. It's a marketing nightmare. But I am very passionate about the position that if my client is this old person who have been empowered to assist and advocate for, I'm going to assist and advocate that person, even in the face of resistance for the person who's paying my bill. That's the way it works. Yeah, unfortunately, the question was about whether a HIPAA release empowers you to speak to medical providers and whether or not a power of attorney is required in addition to a HIPAA release. And the answer to that is you're not required to have a power of attorney in order to get medical information about someone that you're serving from a medical provider. You are required to have authorization under HIPAA because you're not related to that person. If you were related to that person, that Healthcare Decision Act would kick in, so it wouldn't be an issue. The HIPAA laws, and many people don't know what the HIPAA law is, so I'll speak to that a little bit. Healthcare Information Portability Act is what it stands for. And it doesn't have anything, the law itself wasn't intended to do anything but to make our health insurance, I'm sorry, not health information, health insurance, it was only intended to make insurance portable so that when you lost your job, for example, you could take your health insurance with you. Or if you moved from state to state, you still had the portability of certain kinds of insurance. But what became of HIPAA was that there was a small provision in there that was designed to keep your healthcare information private and secure while it was being portable, so that it could be portable without being open to the wide world. And people have used and abused HIPAA as a gatekeeping means. It's really one of the most useless laws on the face of the planet, because I can tell you it's very easy to break into some healthcare facilities' computer systems. So it's kind of useless, but it does allow people that, like you're talking about, who are very ill-trained in a lot of cases, to put up roadblocks to your doing your job. And one of the things that I point out to people is there is no requirement, first of all, that a HIPAA release be in writing. So, for example, if you go into a nursing home and you're working with your client, or a health, more likely an assisted living in your guy's case, and you're working with your client and you need to get some medical information, and you don't have a HIPAA release for some reason, if you go to the nursing station and say, I need to see or I need to find out about her medications, and she is able to authorize you to do that verbally, that's good enough, right? You don't have to have a piece of paper that she signs to do that. The reason they want that, of course, is to cover their butt to make sure they're complying with HIPAA, but it's not actually required. If she can verbally authorize you to get that information, there is no requirement whatsoever for you to have a POA to get healthcare information that I'm aware of. That's usually the kind of statement you'll get from someone who does not want to give you the information for some other reason. It should be written into the power of attorney. It should say somewhere in there, in order to be declared incapacitated, there must be a medical certificate in writing by 2 doctors, or a doctor and a licensed psychologist. Typically it's 2, and under the Healthcare Decisions Act, if there is nothing in the power of attorney, you're going to fall back on what it says in the Healthcare Decision Act, which is exactly what I just said to you. 2 doctors or a doctor and a psychologist in writing would have to do it. And there's loads of neuropsychiatrists around that do this, and neuropsychologists around that do this. There's the Neuropsychiatry Center at UVA that will do it. If you, the problem with them is you have to take them in. Lee Willis will come out to a facility and test people.